Well, hello everyone, and welcome once again to this Your Employment Law session. That's why we're here. That's why I'm here to talk to you about employment law and to hopefully solve those workplace problems you may be facing. So, welcome. I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. We practice employment law across Ontario, British Columbia, Alberta. So if you're in one of those provinces, you're in the right place right now in the right time to get questions answered. So again, this is a live session designed for you to get those pesky issues resolved, those problematic workplace problems dealt with. So if you're dealing with a bad boss, a bad employer, an ultimatum, losing your job being changed, new rules in the workplace, I think you get the idea. This is the time you can ask your questions, get me to read it and answer it and tell you what you need to do. Again, I'm the employment lawyer, Lior Samfiru, practice law across Canada, and I want to make sure you have answers, you have solutions, you have things that you can do because we have very good employment laws. People tell me oftentimes, oh, the laws are not good. Nonsense. The laws are very good. Some of the best employment laws in the world right here in Canada. And if you want to know what they are, what they do, how they help you, you're in the right place. I will tell you. Now, before we start getting some questions answered, let me give you some other contact information. You may want to reach out to me off air, off social media, just to have a private chat or a private email exchange. Very, very easy to do. Couldn't be easier. All you do is you go to employmentlawyer.ca. You see that address on the screen right now, employmentlawyer.ca. When you go there, of course, you will see the contact information, phone numbers, email addresses. If you prefer just to fill out a form and to have us call you, it's all there at employmentlawyer.ca. But that's for after this session. Right now, I'm here with you live, making sure that you have knowledge of all your legal rights. Make sure that you're not wondering, you're not getting stressed out, not losing sleep for no reason if you're facing that workplace problem. So I'm going to start answering questions right now, but I want your question. You have time. Last few weeks, by the way, we've had tons and tons of questions. I love seeing that. So keep me busy, keep me on my toes. Let's make sure you get those questions answered right now. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and let's get to what we came here to do, answering your employment law questions. All right, let's see. Our first question of the day comes to us from Josh. Josh asks, does your employer have the ability to lay you off if they say they're struggling financially? I work in a restaurant and my shifts have been reduced over the past few weeks anyway. So an employer can let you go at any time and pretty much for any reason as long as they pay you severance. Now, maybe it's because the business is slow. Maybe it's for some other reason. Maybe they're lying about the reason. Ultimately, if they let you go, okay, they can do that as long as they pay you proper severance. Now, two things, though, that I want you to remember. Actually, three things. The first thing is if you're let go and paid severance, chances are that whatever your employer is offering you is probably a lot less than what you're owed. You're probably owed 5-10 times that. So that's number one. Number two is with respect to the change in hours. If your employer is reducing your shifts, if your employer is reducing your hours, they may not have a right to do that. That could be a constructive dismissal, and you don't want to accept that. You don't want to give your company the confirmation that you're okay with them reducing hours. Once they reduce your hours and you continue working because you've accepted it, you may then be stuck and they don't have to increase it again. So anytime your hours get reduced, your pay, etc., that could be a constructive dismissal. You want to call me right away. The last thing I'll say is you mentioned layoff. A temporary layoff situation is different. For most individuals, your employer is not allowed to put you on a temporary layoff. If your employer does put you on a temporary layoff, you can decide, you can choose to consider that layoff as a termination of your employment and force the company to pay you severance. So the company may not be thinking that. They may be saying, no, we're not letting you go. What are you talking about? We're just going to send you home for a couple of months and then call you back. Not so fast. In most cases, the company does not have a right to do that. They can't just stop paying you and stop giving you work for a period of time. If they do, you could consider that a constructive dismissal. If you want to do that, you don't do it on your own. You call me. Okay, and you connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. All right, great question. Keep them coming. I want more questions. If you've just joined us, my name is Lior Samfiru. I'm the employment lawyer, and I'm answering your questions live. Whatever the question is, if it touches on your job, employment law, your workplace, I can give you the answers. All right, next question comes to us from Sean. My friend drives a mid-sized delivery truck. For months, he told his boss the brake lights were not working and the truck was not safe. He was fired after refusing to drive it. Wow. Okay. Well, first of all, he did the right thing, of course, by telling his employer that the truck is not safe. Safety is paramount, and the company has a legal obligation to make your workplace safe. In this case, the workplace is the truck. Now, it goes more than that. You have an absolute right to refuse unsafe work. And when you do that, you cannot be fired. You cannot be disciplined. In fact, the company can either fix the problem. If they think they fixed it and you're not satisfied, they have to call in an inspector from the government to determine if it's safe. And that's what they have to do. They're absolutely forbidden, Sean, from letting you go, for punishing you in any way. So what you've described there, completely and utterly illegal. One of the biggest no-nos that an employer can do. So what happens next? Well, what happens next, Sean, is you get your friend to contact me ASAP, okay, as soon as possible. He can contact me through employmentlawyer.ca. I'll give that to you again, employmentlawyer.ca. Phone number's there, email address is there. It's on the screen right now. You can see it. And we can help him get compensation, potentially even his job back if that's what he wants with back pay. There's various options. So, Sean, you give him to call me. Employmentlawyer.ca is where you're going to send them. Thank you for that. Fantastic question. Fantastic questions that I've been getting so far. More have just come in. I'm going to answer them. You got time. You see how easy it is to get those questions answered. I'm going to tell it to you like it is. I'm going to tell you what the law says, what it doesn't say, what your options are, what you can and cannot do. So let's get, and I'm not going to lecture you on the law. I'll just tell you what you need to know. So if you've just joined us, I'm Lior Samfiru, the employment lawyer. As you're seeing, I'm answering your questions live here with respect to employment law. You have time. Have the box on the screen, type it in, hit enter, and I'll read it and then I'll answer it. All right, Taylor asks, I was informed all employees will now be required to sign an employment contract. If we do not sign the contract, our employment will be terminated. I have been an employee here for 37 years. Never taken a sick day and received a perfect review. Do I have to sign this? And if I refuse that, what happens if I'm let go? So let's be very clear. This is extremely important for everyone. If your employer comes to you out of the blue and says, I want you to sign a new employment agreement, that is bad news, always. They're not doing that because they like agreements. They're doing that because there are terms in that agreement they want you to sign that are better for them. For example, it's very likely that one of the terms in that agreement that they want you to sign is a term that limits your future severance. So that could be the difference between 24 months of severance, or if you sign it and then are let go, 8 weeks severance. So the difference between 2 years and 8 weeks, huge difference. That could be tens, if not hundreds of thousands of dollars difference. So I would be very suspicious, Taylor, in this situation. You may want to send me a copy of the agreement, and I can tell you what it does. But generally speaking, you don't want to sign it. Now, could you lose your job? Yes. Your employer can let you go for any reason. But if you've been there for 37 years, if your employer lets you go, they're going to have to pay you 2 years severance. And that's better than signing this and then 6 months later being let go. And now you're only getting 2 months severance because that agreement limits your entitlements. Hopefully that makes sense. But a very important thing for everyone to remember, if you're already working, you have a job, everything's okay, but then your employer comes to you and says, hey, I want you to sign a new employment agreement, be very suspicious, very concerned. It's not good news. It's very bad news. Don't sign anything without having me see it first. Okay, hopefully that makes sense. Follow-up questions, please ask. All right, I'm getting excited here. Those are fantastic questions. So important. Things I think everyone should know about, and that's exactly why I'm here, to make sure you get that kind of information. So I'm going to continue answering questions right now. Let's keep them coming. I've seen a few more just came in. I want more. I want 15 more questions. Let's get going. Let's answer and ask, and let's make sure we have information. All right, Vivek. Vivek has our next question. I complained to HR about the harassment, second time in a year, citing safety concerns being threatened and solicited by the boss. They said they will investigate, but asking to resign as well. Sorry, I'm not sure I understand. They're saying we'll investigate, but you resign in the meantime? Ridiculous. Nonsense. Absolutely. I don't even know what's the right word. I don't even know what the right word. No, no, no. Do not resign. I want you to make sure that those complaints about harassment, you put that in writing. If you spoke to HR, that's fine, but you need to have it in writing because you don't want them to deny later that you've complained. And you tell them, absolutely not, I'm not resigning. If they do anything to you other than investigate, you call me and you call me right away. All right. They have to investigate. And sometimes that may mean they have to bring an outside investigator that knows what he or she is doing when it comes to investigation. But they have to investigate, and ultimately they have to fix the problem. If they don't investigate and they don't fix the problem, call me right away, but do not resign. Okay, do not. Any issues, I'm right here. Okay, you can call me, you can email me. Employmentlawyer.ca is the place you go to. Again, employmentlawyer.ca, place to go to make sure I get a chance to speak to you and help you. Do not resign. That's ridiculous. Yeah, we're going to help you out, employee, but resign. What? Crazy. No, absolutely not. Let's make sure you don't do that at all. Thanks, Vivek. Any follow-up questions? I'm still here. Ask away. All right, guys, I don't know. Something must be in the water because I'm getting fantastic questions today. Really, really important, great questions. Questions that I have to answer because you guys have to know this information. You don't want to be taken advantage of in the workplace. So I'm going to continue answering, hopefully get some more fantastic questions. You got time. Still got about 20 minutes or so. So come on. What are you waiting for? First of all, I'm happy you're here. I'm happy you're watching and listening. I'll be even happier if you ask your question. All right, LC has our next question. My husband was let go from his job last November due to outsourcing for cost savings. He was offered 17 weeks of severance pay and signed an agreement with those terms. However, his employer has not paid any severance pay since February. After several attempts to contact, he was finally told payroll is on a freeze due to cash flow problems. Is there anything he can do? So first of all, it was a mistake to sign that severance offer. I don't know how long LC's husband has worked there, but chances are that the 17 weeks that he was offered and he accepted is a lot less than what he's actually owed. He could have potentially been owed a year pay or 2 years pay. Again, I don't know all the facts here, but he accepted it. Here's the thing though. If the company says, well, for whatever reason, we're not going to abide by it, that's called a fundamental breach. That means that company, you haven't lived up to the agreement. That means I'm not bound by it either. So I can get my full severance right now. So LC, if the 17 weeks is actually a good offer, we can force the company to pay it. If it turns out that it's a bad offer, we can actually get your company out of it and get him his full severance. So LC, you have to have your husband contact us immediately, right away, as soon as possible. Okay, today, let's do this right away. So hopefully that makes sense. I'll be happy to talk to you. Now, I mentioned for LC severance and how much someone is owed and whether it's a good offer or a bad offer. Before I continue answering questions, I want to give you some more information as to how you can find out for yourself right now, if you want, how much severance you are owed. What is the right number? How much you should be getting if you lose your job. How do you find out? Easy. You go to pocketemploymentlawyer.ca. That address is on the screen right now below me, pocketemploymentlawyer.ca, and you simply use our severance calculator tool. That's as simple as that. You click on it, you answer a few questions, and it's going to tell you if you get 10 months severance, 20 months severance, 24, 3, you get the idea. It's going to tell you what the real amount is, not what the company wants to pay you, not what your next door neighbor thinks you should be getting, what the law says you should be getting. Okay, so again, pocketemploymentlawyer.ca, use a severance calculator. People ask me, oh, is it free? Completely free. They ask me, is it anonymous? Yeah, it's completely anonymous. Do I have to put in my name? No. Do I have to put in my email address? No. It's just there for you. If you want, and only if you want, you can also contact me directly from the severance calculator so that I can actually help you get that severance. You don't have to do that. You can just take the information and walk away if you want. So again, pocketemploymentlawyer.ca. Use the severance calculator. Over 2 million people across Canada have done it. Do it as well. All right, fantastic questions coming in. I'm going to continue answering them right now. Remember, I'm still live. Hey, hi, I'm live. Make sure you get questions answered. Okay, let's make sure you do that. All right, let's see. Next question from IH. I'm a hiring manager and my VP is forcing me to be discriminatory in hiring practices. Wow. Am I liable for this if a complaint is lodged against me or the company? What can I do in this situation? Yeah, you're absolutely liable if you hire based on discriminatory practices. And the fact that someone told you to do it doesn't relieve you of that liability. What you do here is actually very simple. You don't do it. You absolutely refuse to hire based on discriminatory reasons. I want you to send an email to your your VP saying, VP, you told me to look at these factors. I'm not comfortable with that, so I'm not going to do it. You want to put in writing that they asked you to do it and that you've refused. If they let you go because of that, that alone is a human rights violation. They can't do that. So make sure you put that in writing, because if there's a complaint, a human rights complaint, they're going to make you the scapegoat. Say, oh, we don't know, it's this person, he was discriminatory, not us. So you want to send in writing to the VP that they've asked you to do that, and you're not going to do that. You're not comfortable with that. So do your hiring practices based on non-discriminatory reasons. Don't take discriminatory factors into consideration. That's illegal. And if your company does anything to you, you call me immediately. Okay? And to call me, of course, you know the address. You just go to employmentlawyer.ca. Phone number's there, email address is there. Everything you need to connect with me is right there. Okay? Wow. Actually, first time I've been asked that question, so very, very important. Thank you, and now you know what to do. All right, let's see. Continuing to answer questions. CS, who's joining us from YouTube. Can a group of employees file a class action discrimination suit against a company that is openly citing gender-based hiring policies? Yes, but if you've been discriminated against, it may be better not to do that as a class action. Only because class actions take a long time. It could be years and years and years. If we do it as individual cases, even if it's 20 individual cases, those can go very quickly. We can resolve them much faster. I'm not a huge fan of class actions unless there's no other real way to pursue it, because they take forever. Okay, not a good way. But you may have rights. If you're being discriminated against, again, I'm not sure I understand all the facts, but if you're being discriminated against, not legal. Now, if someone else is being discriminated against, not you, you yourself can't do anything about it. It's the person that's being discriminated against that has to do something. But if you're being discriminated against, that could be a human rights violation. That could also be a constructive dismissal. You need to call me. So in most cases, no, I won't recommend the class action. There's better ways to do that. Okay, and you just did a follow-up. They're trying to hit a quota, but openly discriminating against at least males and my other gender and any other gender other than women. So again, if you've been affected by this, you have a case. Absolutely. If you can show that that's what they're doing. If you're upset that they're doing that, but you're not affected because let's say you're already working there, then it's the people that have been affected that are able to pursue it. Hopefully that makes sense. Let me know if it doesn't, and I'll be more than happy to talk to you and follow up. And you can always reach me as well through employmentlawyer.ca. All right, if you've just joined us for the last 12 minutes or so of this session, welcome. Thank you for joining us. I'm Lior Samfiru, the employment lawyer, and I'm here right now still answering your questions live. Your employment law questions are being answered right here, right now by me, the employment lawyer. So you got time, 12 minutes, tons of time. Ask your question. I'll see it. I'll read it. You're guaranteed an answer. All right, let's see. Okay. Mark, who's joining us on YouTube, says, I'm a route sales rep, paid directly commission. Do I have to attend unpaid meetings? Also, am I entitled to overtime after 44 hours? So unfortunately, if you're a rep salesperson that are working outside of the office, generally speaking, you're exempt from overtime. So overtime would not be covered. And so in that situation, no overtime. Now, if you have to attend unpaid meetings, generally speaking, the answer to that is yes. And as long as it's not excessive, as long as it's reasonable. If it's going to be hours upon hours every week, no. But if it's every once in a while, yes. As long as the total that you make, let's say in a week, is more than minimum wage, then yes, they can do that. Not necessarily nice, I get it, because you're losing money, but they can do that as long as it's not excessive. If it becomes excessive and starts interfering with your ability to earn an income, you may not have to do that. That could be a different situation. But if it's one of those every once in a while, unfortunately, yes, they can have you do that. Hopefully, Mark, that makes sense. Let me know if you have a follow-up question. Let's see, guys, questions still coming. I have one more here to answer, but I want to answer more than just one. I want to make sure I get a bunch more questions, because then I can feel, hey, I've done something here. I've helped people. I've answered questions and solved some of those workplace issues. So the next question that's coming to me right now is from Andrea. Andrea says, I was on sick leave for about 10 weeks. After I was clear to return by my doctor, I was told the business was slow and to hold off. Can my boss delay a return like this? No, they cannot. But here's what that means. Their failure to bring you back means that you can consider that to be a termination. So you can't physically force them to bring you back. You may be able to say by not bringing back, I'm ready to come back to work. Here's my doctor's note. I can come back to work tomorrow. If you're not doing that, I'm going to consider that a termination. Constructive dismissal, we call that. And now I'm not coming back at all. Now you have to pay me my severance. So your choice is to wait and see what happens. Maybe you give them a bit of time, or you say, no, I'm not okay with this. I'm ready to come back to work. If you don't have work for me, I'm going to take my severance and I'm going to go find another job. So Andrea, those are the options here. If you want to pursue a constructive dismissal, either right now or after you give them a bit of time, you know what to do. Easy, right? You contact me, we make it happen. And to contact me off social media, for everyone and anyone that wants to do that, easy. Employmentlawyer.ca. Again, employmentlawyer.ca. Very, very easy to connect with me. I have a whole team across Ontario, BC, and Alberta. The best team anywhere. I'm very proud of my team. So let's make sure we talk as soon as possible. Okay, let's see. More questions just came in. Love it. YouTube is a popular place for us today. My hair. I've been terminated after being off work on a medical. I never missed a day before. So obviously we need more context here. If you were let go because you were off on a disability leave, then that's not legal. That's a human rights violation. If you were let go for unrelated reasons, maybe the whole department shut down as an example, so everyone was let go, well, they can do that, but then they have to pay you severance. So, okay, and you just said they did not bring me back after the first medical issue I faced. They terminated me with cause and made up 4 points. I have proof that's not the case. What's my options? Well, you have one option and one option only. Call me. Nothing else. There's no option B. You call me, and to connect with me, again, get the phone number, the email address, employmentlawyer.ca. Again, employmentlawyer.ca. If they don't have cause, if they made it up, of course they owe you compensation. You could be owed as much as 2 years' pay, depending on how long you've worked there and your job, your age, etc. So you have significant entitlements. And if in fact they made that up because you were sick and you took a medical leave, that could be a human rights violation. It's illegal. That means you're owed even more compensation. Again, so you asked, what are your options? One option, not options plural, just one. You call me. Employmentlawyer.ca. You see that address on the screen, employmentlawyer.ca, and let's make it happen. Obviously, I want to sit down with you, find out a lot more, see the letter that they gave you, find out exactly what happened. But no, of course, they can't make up stuff so that they can let you go when you're coming back from a disability leave. Not legal. So you know what to do. You're going to reach out to me. Okay. Let's see. Kevin on Facebook. Hey, someone from Facebook. Kevin says, is there a time limit on human rights? Generally speaking, it's a 1 year limitation period for human rights. There are situations that can be extended beyond that. So the devil's in the details. So I'd want to find out exactly what happened, when it happened, who was involved, what was done, if anything, to try to fix the issue. And in many cases, we can extend it beyond a year into 2 years. So I want to obviously find out from you. So again, to do that, to connect with me, especially if time is running out, don't sit on this. Do this immediately. employmentlawyer.ca to connect with me. Again, employmentlawyer.ca. Thanks for that. For the last few minutes of this segment here, if you've just joined us, I'm Lior Samfiru, the employment lawyer. You may have time to just squeak in another question under the wire, so please take advantage, do that. I'm going to continue answering questions like I've been doing for the last 25 minutes. Okay, Divian has a question. What can you do if you feel you and other minorities in the company have been repeatedly rejected for career advancement over a number of years? Now, if there's a few of you and you can show, that it's clearly something is wrong, that here's a group of you that are minorities, none of you have been considered, other people that are not minorities consistently get promoted, etc. That's a human rights violation. That's illegal. You can file a human rights complaint against the company. But here's the thing. It's not the most comfortable thing, let's put it that way, to file legal action, in this case a human rights complaint against a company while you're still working there. So you have to decide if you want to do that. If you do, absolutely you can. But of course, I would want to talk to you and your colleagues to find out, how do we know that there's discrimination? What information that we have? Give me some of the numbers, some of the statistics. And if there is, there could be significant compensation here. There could be a huge, huge problem for the company. They're probably going to want to resolve this quickly because they're not going to want this to become public. So that's what you can do. And if that's what you want to pursue, Divian, you connect with me through employmentlawyer.ca, and of course, I'll help you. All right, let's get through the last few questions. Let's see. Sunny Days asks, I was on sick leave when my co-workers received a wage increase. Am I not entitled to one as well? Other co-workers that were also off received theirs. One of them had to fight for it. Thank you for your time. So if it was kind of a across-the-board pay increase, then of course you should be getting it. If the only reason you didn't get it because you're off sick, that's not legal. That could be a human rights violation. So yes, you are entitled to it. And if your company doesn't give that to you, that could be a problem. And I can kind of give them a kick in the pants, so to speak. But hopefully that's something you can resolve it with them directly, push for it and say, well, I'm very concerned that the only reason I'm not getting it is because I was sick. Doesn't that sound like discrimination? And in many cases, the company is going to say, yeah, you're right. We're not going to do that. We're going to give you the pay increase. But if you need my help, again, employmentlawyer.ca. All right, I'm going to take one more question, I think, from JJ Singh. I was recommended for a lead hand position. I worked 13 months without pay, including 1 month of training. Now, when I asked about the official role and pay, I was demoted without being paid. So I'm not sure. Are you saying that you worked for free for 13 months, or were you working in a position but were getting paid for a different position? If you were working as a lead hand position but getting paid for a lower position for 13 months, I'm sorry, that's not something you should have done. But you agreed to it, you accepted, you did it for 13 months. So you may not be able to do anything about this whole situation because you're stuck now. If they weren't paying you at all, you were working for free. No. That's completely illegal. You need to call me as soon as possible. So hopefully you kind of understand that distinction there. But generally speaking, here's a very important rule. If your employer does something to you that they're not allowed to do, and you just kind of put your head down and continue working, you're considered to have accepted it. Even though what they've done may have been completely illegal, you're considered to have accepted it, and then you can't do anything about it. So if you're thinking that your employer is doing something they're not allowed to do, you don't have a huge window to deal with this. So you want to call me right away, at least to understand what your rights and what your options are. Okay? Don't sit on those rights because they can disappear. Guys, that's the time that we have here for today. Thank you so much for joining me. Lots of questions. I love it. Listen, I'll be back next week to do the same thing at the same time, but don't wait until then. If you need my help, myself and my team are here. We're ready. We're not going to ask you to wait. So contact us through employmentlawyer.ca and let's get going. Guys, thank you. I'm Lior Samfiru. Real pleasure to have you join me today. We'll talk to you all again very soon. Take care.